Good morning.
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 So it's a nice sloshy mess this morning with all the melting. Well, welcome to this morning, Monday, the 22nd, First District Court of Appeals. So we have 3 cases scheduled for oral argument. And the first case that we have is State of Ohio versus Samantha Davis, which is case number C190302. If parties can please identify themselves and their readiness to proceed.
Good morning, Your Honors. Krista Gieske on behalf of Defendant Appellant Samantha Davis, ready to proceed.
Good morning.
Good morning, Your Honors. Mary Steer on behalf of the state, ready to proceed.
Good morning. Attorney Gieske, would you like to reserve time?
Yes, Your Honor. I would like to reserve 3 minutes, please.
3 minutes. All right. Whenever you're ready.
Okay. Good morning. May it please the court. Ms. Steer. When the Hamilton County coroner refuses to talk about certain gruesome photographs at trial, that should be a major red flag. The state's refusal to accept Ms. Davis's stipulation as to cause of death paved the way for the admission of erroneous admission of multiple gruesome photographs of 2 bodies in the twisted wreckage of a car accident. The inflammatory emotions conjured up by these images drove the jurors to reach a recklessness finding that was not supported by the record. These multiple injustices scream for reversal in this case. I will discuss assignments of error 1 and 2 in tandem, and I don't want to spend too much time on the stipulation. We are advancing a novel legal argument here, and this court will either choose to accept it or reject it. It could, of course, be limited to vehicular homicide cases where the cause of death is, by definition, operation of a vehicle. What I really want to focus on are the gruesome photographs in this case. And here,
well, let's assume that we agree with you on the 403 issue.
Okay.
I didn't really see an argument in your brief as to how that translates into reversal, assuming there is some use of discretion in admitting the photographs. I mean, you have a jury that rejected other claims, so it doesn't seem like the jury was so swayed by the emotion of these photographs that they just kind of reflexively decided for the state. So help us out there.
Well, the emotion is part of the equation, but the other part is that, 403 involves this balancing, and what are the images probative of? When you have that ag vehicular homicide is death by operation of a vehicle, either recklessly or negligently, what do those photographs go to? Really nothing. They are, by nature of the operation of 403A, they must be excluded. So that is just how this court should construe and apply. This is a textbook case for that rule, that there is no probative reason for those to even balance out the prejudice. They're just prejudicial.
But how does that translate to reversal is the question. I mean, is it automatic if we find that they were prejudicial, that it's automatic reversal, or do you have to show some sort of prejudice?
I believe the prejudice is in the recklessness finding, where that's where it ties in with our sufficiency assignment of error. That is just not supported by the record. So what we have here is a jury that had those images, took them back with them to the jury room, and then said, well, this is a tragic case all the way around. We can't let her off completely. We need to make her pay somehow. And then if you look at just the legal standard for recklessness, it's not supported by the record. And I can go into that assignment of error if you'd like, but that's where the prejudice lies.
Yes,
we really go, okay.
And,
really
before you go there, staying on the second assignment of error, if we were to agree with you on the admission of these gruesome photographs, is it a reversal or does it get remanded for a new trial?
If it was solely a reversal on assignment of error 2, that would be a retrial. However, we would encourage you to decide that in tandem with assignment of error 3, the sufficiency, which is really where the heart of the case is, that the recklessness finding is not supported by the record. If it was purely a reversal on assignment 2, it would be a reverse and remand for new trial. So the recklessness finding, this is a difficult case. Like I said, the facts are tough. It's tough all the way around, but recklessness is really an awareness standard. So recklessness has to be a heedless indifference and a disregard for a substantial, unjustifiable risk, versus negligence is a substantial lapse of due care and a person fails to perceive or avoid a risk. So here, failing to appreciate that a tire with a slow leak could lead a truck to hit an overpass wall, catapult over the side, and land on another car. When 30-year police veterans have never seen anything like this before, how can you attribute such knowledge, that awareness, to this defendant?
But for clarity, there was one of the officers testified that it appeared that there was a tire that was low.
Yes.
Okay. And then there's fix a flat tire.
Same
Are they
tire.
the same in the record, or are those two different tires?
Yes, it was the same. I studied the pictures and the accident reconstructionist testimony, put those together, and to make sure of that fact myself. And it was Ms. Steer can correct me if I'm wrong, but I believe it is the same. The right rear passenger tire is one and the same, the underinflated and the fix-a-flat tire.
And did the state accident investigator testify that the flat or the issue with the tire is what caused the accident?
He said at most he can see an overcorrection with an underinflated tire, but and his to his credit, he does testify very fairly. He didn't try to say, he said, I can't conclude she's speeding. I can't conclude the truck was mechanically defective. The best I can say is an overcorrection with an underinflated tire, which again, we would submit amounts to at most negligence.
Well, but I guess part of my concern is, was there an actual causation testimony by that expert or anyone else that said this particular problem with this car or this truck led to the accident?
Right, not definitive, Judge. So at most, again, the state had to make the case circumstantially, and they had to reach a bit because their experts wouldn't definitively say, yes, A caused B, and that's how we got here. They're like, well, at most, I can conclude this. And so what I believe the heart of the case is, under the Laub case out of this court, a vehicle that is unroadworthy can be reckless to be driven. But, for one, if this court were to hold that every jalopy on the road is unroadworthy, a lot of poor people, a lot of college students who are scraping up money to buy their first car could be on the hook for vehicular homicide if they happen to be in a wreck. There has to be something more. And just because this car had some quirks, it had some rust, which a lot of cars have. It had this seatbelt that didn't work. That made it unsafe for her to be driving, but not for other people per se.
So even let me ask you this. So even if we were to say, hey, there was causation tying it back, doesn't the state still have to establish that there was a substantial and unjustifiable risk with that particular fault of the vehicle?
Correct, Judge. And that's where
what was the evidence to that?
Exactly. So we would argue that there was none. That's why this does only establish satisfy the negligence standard. That a person driving a car with one tire they knew had a slow leak would not be a substantial and unjustifiable risk. Again, a lot of cars have these issues. Look around when you drive around today. A lot of these cars, if you were to hold that this is enough to be reckless, a lot of people on the road are reckless right now. There must be something more, a heedless indifference to a substantial unjustifiable risk. If you look at the cases cited in our brief at pages 20 and 24 to 26, these are cases where these kinds of conduct, like speeding through a neighborhood while drunk or knowing your brakes don't work, and a lot of people are out in their yards, those are things that qualify as a substantial disregard to a known risk.
Was there any evidence that she knew that there was a risk or a substantial risk?
Not in, if her testimony is examined, she testified, yes, I put the kind stranger helped me put fix a flat in it and told me just to drive for 20 minutes to perfect the seal. She didn't say, I knew I shouldn't go above, X number of miles per hour. In fact, all the evidence points to that she wasn't speeding anyway. And it is our position that that's not enough to rise to negligence.
Wasn't there evidence, wasn't there also on the tire evidence that she might have had that fix a flat put on days before the accident?
It was Sorry, go
Would
ahead.
that, I mean, I'm just wondering if that would be enough to say, well, she never fit, I understand if it was the day of, but days before, knowing that you had this leak and you're still driving the vehicle, would that be enough for recklessness?
We would still say not for recklessness, because it has to be, could she have foreseen that this kind of accident would have happened, that this extreme of an accident would have happened? And there was evidence that like 2 or 3 days before, she was going to try to sell this car because she needs money very badly. She was going to try to sell it. She put a little bit of air in
Wouldn't
it.
it be enough if the state had put on evidence that engaging in a fix of flat a certain amount of days and driving on the vehicle thereafter, that there was an inherent risk to that?
I still would not say that possibly, yes, an inherent risk, but remember the standard for recklessness is pretty high. It has to be, an unjustifiable risk. And that might have been, she wasn't aware, she didn't avoid a known risk. Again,
My point is this: was there any evidence as to the risk of driving on a fix a flat tire for an extended period of time?
To that point, Judge, not really. No, the state didn't elicit testimony about really about fix a flat and its parameters from anyone who would have had knowledge.
Well, one thing you said is like she couldn't have foreseen an accident, this horrific. But that's not really what we're asking. What we're asking is, could she have foreseen some type of accident, right? So if your tire is poor and it explodes and you bump into the car in front of you, hopefully you don't cause catastrophic damage. But that could still be reckless, couldn't it?
Again, there is a risk component to the negligence definition as well. So is that an unjustifiable risk is what it comes down to. And, a lot of people have like tire issues. It's very expensive to fix tires. So it would be our position that, you're right. The extent of the catastrophic, is not the focus. Was it reckless to drive this vehicle in particular? And even with all of its problems and quirks, our position would be no, that it doesn't rise to the level of recklessness. And, one point I want to quickly hit upon is that the state invites this court to bring the impairment factor back in, and we would argue that's improper. Typically, when findings of fact are supported by competent, credible evidence in the record, this court doesn't revisit them. So it's not the time to relitigate that issue. The jury found that issue in her favor. Similarly, the driving under suspension under the case law is also not evidence of recklessness. So, the vehicle wasn't found to be unsound. So what we have here again is, if there are no further questions, I won't harp on the issue.
And we'll reserve your 3 minutes.
Okay, that would be fine. I'll reserve. Thank you.
You have about 1 minute left.
Okay, I'll reserve. Thank you, Judge.
Okay.
Morning, Your Honors, Ms. Keys.
Good morning.
May it please the court. Let me start with the third assignment of error and the sufficiency. This isn't just a question of a bad tire. It's many circumstances, and although the jury.
Well, Ms. Steer, let me help focus you on that, because like I read all these problems with this car, and like I get it, it is a bad car, but but like the problem with the door handle didn't cause this accident. The corrosion under the seat didn't cause this accident. So specifically, what on this car caused the accident, and what is her knowledge on that?
Well, I'm not sure that it was necessarily just the truck itself that caused the accident, but the bad tire that she was driving on, she said it herself when she was talking with Officer Payne in state exhibit number 17. She said, I did have a flat tire that was filled or fixed with a fix-a-flat a few days prior. So I was nervous when the car behind me, this is when she's talking about the supposed car that was driving behind her. She was nervous because it was tailing her too close. And then when he asked about her speed, during her testimony at trial, when she was asked about her speed, she said, I wouldn't drive that fast, first of all, on a bad tire, and second of all, around a bend. So she knew that there was a risk.
So are you saying that expert testimony was not required, that the layman testimony of concerns of the defendant is sufficient? to establish a substantial and unjustifiable risk?
I think with all of the combination of circumstances, it was sufficient without expert testimony. We have her knowledge that she was driving on a bad tire. And although Ms. Gieske would try to discount her impairment, although the jury found her not guilty on counts 1 and 3, there's still, they could consider her impairment in counts 2 and 4. There was plenty of testimony that she was impaired. Whether or not it arose to an appreciable amount for counts 1 and 3, it could still count as impairment, like in the case State versus Crabtree that I cited in my brief.
Let me go back to the truck issue for a minute. I mean, would you agree with me that if an expert came in and looked at this truck and said, you know what, the result of the cause of this accident was a bad transmission, which is something she had no knowledge of, that would not rise to reckless? Would you agree with me on that?
Yes, if it was just that, and we could set aside everything
So
else.
then, like, going back to the tire issue, I mean, I think Ms. Gieske is correct that there are a multitude of drivers that drive on underinflated tires that are, you know, beyond their life or their supposed life. And does that mean that all of those drivers can be found reckless if the tires blow and they have an accident?
I don't know about all drivers. I think if you have drivers who are driving impaired with bad tires and going as
I know. Well, let's leave the impairment issue alone, because I just want to understand the state's theory on the vehicle. Like, if I'm driving and my tire pressure light comes on and I ignore that because I'm busy and I need to go somewhere else, like, is that enough?
I would say not.
So in this case, it has to be the combination of the tire with evidence of impairment is what your argument is?
I think evidence of impairment and also evidence of her speed. I think it was a combination of unsafe driving around a bend, the on-ramp from 275 onto, or she was going from 71 north onto 275 west, and she was rounding the bend. Shane Meyer, who testified, he was the guy who was the off-duty trooper, said that she was approaching him. He was going about 50 to 60 miles, and he was getting nervous because she was approaching him fast, and he estimated she was probably going 65 to 70 miles an hour, which was, he thought, too fast to go around the bend. And even she said she would never drive that fast, especially on a bad tire. And
what is the speed limit around that bend?
I think that the testimony was that there was no different speed limit. Like, there's not one of those signs that says, you know, whatever, 40 or whatever. I don't think that it's actually marked to go from when you're moving from 71 to 275.
I mean, is it the state's theory then that like she shouldn't have been on the interstate at all with that car and the tires?
I think she knew that there was a risk and she disregarded it. She disregarded it and went on the highway. I think there was other routes she could have taken if she had to drive the car. But the fact, you know, and I don't think that you can eliminate the fact that she was doing this while she was under the influence of some drugs and also going too fast around a curve.
Okay, so let's talk about the drugs for a second. Was it the toxicologist who said that the level of whatever the substance was in her was consistent with impairment, but then he didn't offer an opinion as to whether, based on her conditions, her tolerance level, that she was impaired? Is that right?
Right. The trial court wouldn't let the experts, either expert on either side, talk about her, whether or not she was impaired at the time of the accident. She limited what they were able to.
Wasn't there a Glasgow coma scale that was done on site, and she scaled very high? I think only 2 or 3 points of short of the highest of her awareness and alertness.
Yes. But I'm not sure that has any reflection on impairment. I think that that's like for purposes of head injuries.
But on cross-examination, wasn't there a lot of questions with regard to indicia of impairment? And the officer testified that ultimately that there was none?
I don't think anyone testified that there was no impairment. I think,
I'm talking about indicia.
right. Well, he was cross-examined, and it was a pretty, when you read the transcript, it was a pretty strong cross-examination by the defense counsel as far as following the manual. But when his testimony wasn't about giving her field sobriety tests, he was more there as, even though he was a trooper, he just happened to be there, and he thought that she was impaired. He didn't really talk to her or try to do an investigation at the time.
Right. But even absent, I mean, you're right, he did not perform a field sobriety test, but he, other indicia from the manual were asked, the eyes and the speech and so on, and none of the indicia he had not observed any indicia.
He didn't conduct any of those tests, correct? Correct. So he hadn't observed any of that because he wasn't really in the position to observe any of that. She was being helped by, I think, a nurse and another person who had stopped on the way. He just thought the way that she was acting, he said she was acting spacey. She kept saying she needed her truck and she needed to get to work. And for that reason, he thought she was impaired. But I think that, as much as counsel tries to discount his testimony, he also, his testimony wasn't relevant only on the issue of impairment. It was also on the issue of her speed that she was gaining on him, going fast around the bend. And also he discredited her testimony about whether or not there was a second car. She tried to say that there was a car that had clipped her and someone had been following her close. There's absolutely no evidence of that. So that kind of made her statement incredible.
Yeah. Was there any forensics that supported speed on her part?
There was not. They could not establish how fast she was going. All that could be established by Officer Swartout was that there was no braking. So there were no tire marks that indicated that she was braking when she hit the wall. And Meyer, who was driving in front of her, said that he saw her kind of go side to side, go to the left, and then turn sharply into the right wall. And that's when the car was bolted.
So on the experts, didn't there seem to be a theory that arose that perhaps the brakes had given away and that could have been the cause of the accident?
I think what Officer Swartout said was that he couldn't tell what had happened. He said either she didn't hit the brakes or there were no brakes, but that's as far as he could go. The truck, I'm sure you've seen the pictures, the truck was destroyed. I don't know that you could ever test to see what had happened before because it was in such a condition after the crash.
Aren't the tires, when I reviewed the pictures, the tires seems to be part of the, seem to be available, were they not?
There was one tire I know that was embedded in the victim's car. And then I think there was another tire on the side of the road. Yes, I don't know which tires they were. I'm not sure if there's testimony. I'm sorry, I can't recall whether or not there was testimony about which tires those were and which one. I actually think one of the, if you remember, there were the people who were traveling down 71 going to Gatlinburg, and there were a couple of witnesses who testified. And I apologize, I can't remember which one, but I think they actually saw a tire flying when the truck came down. I think a tire was flying off at that time.
Was there any evidence that there was an attempt to, or that it was impossible to do so, to test the brake pads on the vehicle?
I believe Officer Swartout said that there was no way, that the truck was in such condition that they couldn't test anything.
But specific to the brake pads, was that ever parsed out?
No, I don't believe so.
So we don't really know what caused this accident. I mean, that's where I'm getting a little hung up, is what caused this truck to jump over the overpass?
Well, I think it was caused by Ms. Davis's reckless driving. You know, she's going fast around the curve. She lost control of her truck and slammed into the wall, which vaulted it over. I mean, the fact that it vaulted over, she had to have been going, I would say, at some pretty good speed to make it go over.
But maybe, it could have been a brake issue, right? I mean, the brakes could have given out and we don't know.
Correct. We don't know what, all we know is that she was driving fast and hit the wall.
Was there any expert testimony that that there was great speed or a certain amount of speed that was required for the vehicle to vault over?
I don't think there's any testimony about what speed what it would take to get a truck to go over the edge. Actually, I think that there was testimony that the walls of the exit ramp are built to prevent, to kind of keep the cars from going over the edge there.
Mm-hmm. Okay, thank you.
If I could quickly, unless you have any more questions about this.
No, you still have 4 minutes.
Oh, okay. No, I just wanted to kind of switch gears and talk about the pictures and the requests to stipulate. First of all, as I say in my brief, as far as the stipulation, I think that this kind of falls outside of Old Chief and Creech. I think the Old Chief and Creech, a lot of it was based on kind of the same danger that we see with other acts evidence and the problem with propensity evidence. The state doesn't have to accept a stipulation as to a death because it gets a chance to prove its case. And then, so we get to put in the pictures.
Creech dealt with prior convictions.
Yes.
Which is quite different than what we have before us, is it not?
Right. And I think they talked about it as being something outside of what actually happened in the case. Here, the death is really what this case is about. Two women died because of this crash.
Well, so I agree with you on that, but I guess the question is, once you can show like pictures that shows the basic accident and how horrific it was, do you really need to show the pictures that show the details of how gruesome their death was? I mean, what is the probative value of that?
Well, I think that the pictures, we're really talking about 10 pictures when we're talking about it. The first one's 5C through E. I think even in Davis's brief, they can see that the state probably could have allowed those in, that they were more benign.
They focus on 13O through 13U.
Right, yes. And so of those, there were 7 of those, and the coroner used those as part of her testimony. Besides the fact that it showed kind of the effect of the accident, the coroner also used those as part of her testimony. She used, I think, 5 of the 7 of them in lieu of using autopsy pictures, because she said that the autopsy pictures were too bloody and that the pictures from the scene showed better what she was going to talk about. So she used those. There were, I think one of them I think it was 13Q she thought was repetitive, and then she didn't want to use 13U. But the other one she used as part of her testimony is when she was describing the cause of death of the 2 victims. But so either of those, or if you look at that, there's really not that many pictures that were even questionable. They are gruesome. There's no doubt about that, but it was a gruesome crash that happened, and it was a gruesome.
It was an absolutely tragic crash.
Right. But the state does have the opportunity to show, if I were on a jury and someone said this truck flew out of the air and landed on a car, there would be some part of me, and I think that shows up, I think, in Creech, where they say, the jury has a chance to kind of see how it all comes together, and the state is able to present that to the jury. And so that's what, the state has to use or gets to use the pictures to explain the course of the investigation, how these, what happened with these cars. And also, like, when we're talking about whether or not there was any investigation done of the truck and what happened to the truck, when you see the damage that was done in these pictures, I think then it also helps you answer the question, why wasn't there any investigation done of the damage to the trucks? Or why didn't we try to figure out the cause based on what had happened to the truck? And regardless, even if even if the court abuses discretion in allowing in the pictures, it would be harmless error, because in light of all of the other evidence, these pictures compared with everything else aren't overly prejudicial and didn't really change the outcome of the case. As I think Judge Bergeron, as you pointed out, the jury clearly didn't use these as to kind of act emotionally against the defendant, as they were able to distinguish between counts 1 and 3, and they found Ms. Davis not guilty of those, and then found her guilty of the other remaining counts.
The state didn't even show those again in closing argument.
Right. I believe that they showed one, which was, I think, Ms. Tell's hand on the stick shift, or on the gear, just to show that she hadn't that there was no break, that it happened instantaneously. And then I think she said, you'll have them back, but I'm not going to show them to you again.
Okay. But weren't the pictures shown twice, once with the sergeant's testimony and second with the coroner's, with Dr. Stevens' testimony?
Yes. So the detective used them to show kind of how, I think, to talk about the whole investigation of the accident. And then the coroner used those pictures. I guess conceivably the coroner could have used pictures from the autopsy and pulled those out to describe the cause of death, but she chose instead to use the pictures from the scene, because she said that the pictures from the autopsy were too bloody. And so, and I think the pictures from the scene showed better what she was going to be describing in her testimony.
I'd like to go back to a point that you made. I think it's an important point to talk about, and that is that that the condition of the vehicle left it in such a way that it would have been impossible to do any forensics on it. And you asked us to look at the pictures, and that the pictures would it be indicative of that, or would support that, or would establish that. I'm not sure which one you're asking us to do. And so that's what I'm trying to figure out. Like, what is our role in looking at, there's no evidence other than we don't believe we could have done any forensics, so we did none. There's no evidence beyond that establishing that forensics could not have been done. So what are we to do with that?
Well, as far as reviewing what the jury found, there was sufficient evidence. As long as there's sufficient evidence, and then this court's going to act as the 13th juror to determine whether or not the jury totally lost its way in finding Ms. Davis guilty of aggravated vehicular homicide. So it's not, although, I think there's some other evidence that maybe we would all like to have in the record. I think we have to look at what's there and what the jury was looking at, and whether or not that means that they lost their way. And I don't think that they did.
So what you're saying is that it didn't necessitate any determination on the vehicle? Is that what you're saying?
I'm sorry, Judge.
Are you saying that the evidence stands on its own and it doesn't require any evidence of the condition of the vehicle?
I think that we get to Ms. Davis driving recklessly without understanding the condition of the vehicle, other than the bad tire that she was driving on. And I think that her testimony, even she concedes that in her testimony, that she knew she was driving on a bad tire and that she shouldn't be going fast around a curve. And so I think that that's sufficient. And I think when you add that in with her impairment and her speed, I think that that's sufficient to find that she was driving recklessly. And I think that the weight of the evidence, I don't think the jury lost its way when they convicted her of the offense.
Thank you, Attorney Steyer.
Thank you.
Attorney Kieske?
Thank you, Judge. Trying to decide which points I want to get to first. So a couple of points. With the state keeps hearkening to the alleged impairment, alleged speed. The record actually does not support either one of those findings. Sergeant, I might butcher his name, Platje, testified that the speed limit in that area was 65. There were no signs decreasing it around the bend. The accident reconstruction report concluded that she was going 45. That's 20 below the speed limit. In no world is that speeding. Also, regarding the alleged impairment, this came down to, the people that were there to observe her. I think Judge Zayas, you touched upon this. So paramedic Scott Reed treated her on the scene, Ms. Davis, and in his report, he said he did not notice any signs of alcohol or drug use. No paraphernalia, no bottles, no smell of alcohol. Nurse Zimmerman, who was the ER.
That would be very compelling evidence for the jury to assess. I guess, as we're evaluating sufficiency, what about the toxicologist and I think it was a toxicologist, and his statement that the level in her system was consistent with impairment.
Right, and so it did come down to a battle of the experts, and both experts agreed that the level of marijuana metabolites, it was an inactive component, would not have impaired her. So get the marijuana off the table. It all comes down to the oxycodone component. And Topmiller said that it could be consistent with, the way he put it, I believe, was some degree of impairment. Again, that's not definitive. And then Bellato comes in and uses this, it's a mathematical pharmacokinetics analysis is what he called it, that has to do with absorption and metabolizing chemicals. And he says that it wouldn't have been consistent with impairment. So obviously when it comes down to it, the jury believed him, and Topmiller's testimony was not definitive enough that she was impaired. He said, yeah, it could be some degree of impairment. There's a beyond a reasonable doubt burden here. That is not enough. So it'd be our position that it's not sufficient evidence. Trooper Meyer was thoroughly and
so what you're saying is the expert testimony is that based on what came in the toxicology report, that there could have been impairment as opposed to that there was impairment.
Agreed. And again, she was, the impairment, she was acquitted on the OBI ag vehicular. So is there evidence of impairment to support a recklessness finding? And the state wants us
that's
to.
Where I'm going. So if there's evidence that she could have been impaired, then
Yes.
We need to look at whether there was evidence that she was in fact impaired.
Right. And all of the other evidence supports that no, the people on the scene, when they drew her blood, there was evidence it was consistent with what she said, taking a Percocet the night before. Trooper Meyer walked back his testimony about speed, about impairment, when he was thoroughly discredited on the witness stand. And as a final point, it is not proper to somehow aggregate multiple non-reckless findings to reach some sort of recklessness finding, kind of like cumulative error. When all of these things are not reckless, you can't somehow throw them all in the pot and say recklessness. And I think that's what the jury, in order to split the baby, ended up doing. As far as the pictures, the pictures and the testimony about extricating the bodies, it would be our position that, again, those go to absolutely no element, that there was less inflammatory evidence. As a general rule of evidence, when there's less inflammatory evidence available, you go with that. And here, they didn't need to see, a close-up shot of a vacant stare of a dead body. They didn't need to see brains in a bag. Those were not probative of any element of aggravated vehicular homicide.
However, the record does show that the physician testifying for the coroner has stated that the coroner's pictures were too bloody and would not have been useful and effective to be presented during his testimony.
That is true, Judge, but why? I understand the jury has an expectation and a curiosity to see the narrative brought to life. Why do we need a bunch of pictures? There are pictures of the wreck with the roof still on the car that you could kind of see the bodies. There was a picture farther away of the roof removed with the bodies where you couldn't quite see the gruesomeness. Those would have been sufficient. Then the coroner can testify without pictures. We can see the bodies are dead. The coroner can say cause of death, severing of the spine, crushing of the brain, instant death. That's all we need. And the state simply didn't need to go beyond, and the effects were tragic. So like I said, that the recklessness finding was reached improperly here.
If you want to make a wrap-up statement.
Sure, if there are no further questions, yes. So Ms. Davis should not be sitting in prison basically for a conduct that amounts to negligence at most. So we would ask this court to reverse and discharge, or at a minimum to reverse and remand for a new trial. Thank you.
Thank you both for your arguments this morning.
Thank you.
Thank you.
You know, definitely a very, very tragic, great loss and what should have been a special day for this family. We will take the matter under submission and issue a timely decision, and wish you both a safe and wonderful afternoon.
Thank you, Judge.
Thank you.
Good morning. Is Mr. Fry there?
Mr. Bay is here.
Pardon me, who is there?
Timothy Fry Bay, B-E-Y.
Okay, Mr. Fry Bay. Is that correct?
That's correct.
Okay. Thank you for joining us
That's
this
a record
morning.
reflect.
So we are here
Yes,
now
yes.
on the case of State of Ohio versus Timothy Fry, which are cases number C190511 and 512. If both parties can please state their names and their readiness to proceed. We start with Mr. Fry. You're right now, your phone is, you've hit the mute button. If you can unmute yourself, because we cannot hear you. Mr. Fry, if you're speaking, we are not able to hear you because you have your phone on mute, and so we are in dead silence. Mr. Fry, I don't know if you can hear us, but we are unable to hear you completely.
Judge, I'm going to move Mr. Fry to the waiting room and bring him back in to see if that helps the audio issue.
Okay, thank you. Thank you for your patience, Attorney Dieters.
Oh, yeah, no problem. My name is Elise Dieters, counsel for Plaintiff Appellee, the City of Cincinnati.
Okay, Mr. Fry, it looks like your mic is on. Are you able to hear
I'm
me?
sorry. Can for the record, can who's presiding over these proceedings be stated?
Okay, so you are with the First District Court of Appeals this morning. My name is
Yes,
Judge
ma'am.
Marilyn Zayas. And in
Hi,
addition
Judge.
to myself, we are joined with Judge Beth Myers and Judge Candace Kraus. And so this morning you have 15 minutes to argue your position. We can reserve whatever portion of those 15 minutes that you would like, so that after the state completes their 15-minute argument, that you can come back and rebut. So if you were, for example, to reserve 5 minutes, that would give you 10 minutes at the onset. The state would argue for 15 minutes, and then you would come back for 5 minutes. Would you like to reserve some time?
Yes, ma'am.
And how much time would you like to reserve?
I would like to reserve 10 minutes.
10 minutes. So what that means is you're going to have 5 minutes to argue now, then the state will argue, and then
Okay.
you will have 10 minutes to rebut. Okay?
Thank you.
All right.
Okay.
Whenever you're ready, you can get started.
Okay. First of all, I'd let the record reflect that the state violated the Brady Act by discovery that wasn't adhered to. Also, a demand for jury trial was placed that was totally ignored, which violated constitutional rights, and automatically a violation of Rule 38, right to a jury trial, violated due process, challenged jurisdiction repeatedly. The state never proved jurisdiction. Stated initially when I was pulled over, and constantly under threat, duress, and coercion did I attend court. All affidavits was totally ignored, which is a violation of law. I stated to the court upon which I was traveling upon the public highways, which I have a right, according to this Constitution of the United States of America Republic. In addition to that, the right of a citation to travel upon public highways and to transport one's own property therein, and the ordinary course of due life and business is a common right, which I have under the right to enjoy life, liberty, and to acquire and possess property, and to pursue happiness and safety. It includes the right in doing so to use the ordinary and unusual conveyances of the day, and under the existing modes of travel include the right to drive a horse-driven carriage or wagon therein, or to operate an automobile therein for the usual and ordinary purpose of life, business. It is not a mere privilege, like the privilege of moving in a house or a street, operating a business, or to stand in the street, or transporting persons or property for hire in the street, which a city may permit or prohibit at will. That's Thompson versus Smith, 155 VA 367, 154 SC 579, 1930. The right to travel is a part of liberty of which the citizen cannot be deprived without due process. And under law of the Fifth Amendment, that's Kent versus Dulles, 357 U.S. 116, 125, 1958. The right to travel and to go from place to place is a means of transportation, permit. It is a natural right subject to the rights of others and to reasonable regulation under law. A restraint imposed by the government of the United States upon this liberty, therefore, must conform with the provision of the Fifth Amendment that no person shall be deprived of liberty without due process of law. Stackman versus Dulles, 96 APDC 287-225F2D 938 at 941. The government is requiring the people to obtain driver's license and accepting vehicle inspections and DUI roadblocks without question. Is restricting, therefore violating the people's common law right to travel. This is a new legal interpretation. Is this a new legal interpretation? It isn't, judges. Apparently not. This means that the beliefs and opinions of state legislators, the courts, and those in law enforcement have acted upon for years have been in error. Researchers armed with actual facts state that case law is overwhelming in determining that to restrict movement of the individual in the free exercise of his right to travel is a serious breach of those freedoms secured by the U.S. Constitution and most state constitutions. That means it is unlawful. The revelation that the American citizen has to always have the unalienable right to travel raises profound questions for those who are involved in making and enforcing state laws. The first of such questions may very well be this: if the states have been enforcing laws that are unconstitutional on their face, it would seem that there must be some way that a state can legally put restrictions such as licensing requirements, mandatory insurance, vehicle registration, vehicle inspection, to name just a few, on a citizen's constitutionally protected right.
Mr. Fry Bay,
For this,
you have 1
I'm
minute
sorry.
left. If you'd like to continue to reserve your 10 minutes.
yes. And Geraldo versus California, 110 U.S. 56, the U.S. Supreme Court states very plainly, the state cannot diminish rights of the people. And in Bennett versus Boggs, 1 bar with 60 statutes that violate the plain and obvious principles of common right and common reason are null and void, ab initio. The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis versus Welsham, 263 U.S. 22 at 24 1923. Where rights secured by the Constitution are involved, there could be no rulemaking or legislation which was abrogated. Miranda versus Arizona, 384 U.S. 436 491 1966. Excuse me. Do I have any more time within that 5 minutes, or is my time?
You already, yeah. So we're going to reserve your 10 minutes, okay? And now we're going to hear from the state represented by Attorney Dieters.
May it please the court, as stated earlier, my name is Elise Cedars, counsel for the plaintiff appellee, the city of Cincinnati. As noted in my brief, Mr. Fry's appeal does not articulate specific assignments of error as required by the local appellate rule 16. The state did its best to convey, or did its best to respond to the issues it believes Fry was attempting to convey. I styled the first assignment of error to be based on insufficient evidence. Considering all the evidence in a light most favorable to the prosecution, a rational trier of fact could have found all the elements of the 3 charges beyond a reasonable doubt. As this court knows, deciding whether a conviction is against manifest weight, deference is given to the trier of fact. In this case, the evidence is the officer's testimony based on his observations and investigation. Officer Stout testified that he observed Mr. Fry turning left onto SD Avenue from the curb lane to the center lane instead of curb lane to curb lane as required by the city code. Additionally,
just a quick question on the left turn.
Yes.
Does it matter? I know that the city code has different ways to complete a left turn depending on if you're going from a two-way road to a one-way or a one-way to a two-way. And I didn't see anything in the record about whether it was a 2-lane to a 1-lane or a 1-lane to a 2-lane. Does that matter in this case?
It does matter in this case. The prosecutor Conitzer told me, and apparently it was 2-lane to 2-lane. And Mr. Fry took a wide turn from the curb lane side to the center lane. So you're supposed to stay in the lane to which you turn. And apparently he turned, made a turn too wide into the center lane.
Is that in the record though?
I don't know if it is in the record, but the officer testified to it being too wide of a turn and an improper change of course from lane to lane.
Is that enough?
I believe it is. Let me make sure. Yeah, so yeah, the officer did cite, he said it was a red light, but he swung it right, went from curb to center lane versus curb to curb. So it was in the record. I apologize. As I was saying, then the officer stopped Mr. Fry, saw that his front windshield was cracked in violation of the blurred windshield statute in the city code. And Officer Stout then ran Mr. Fry's record with the Bureau of Motor Vehicles and found that he was under a non-compliant suspension since November 17th, 2017. The incident took place on November 30th, 2017. The state presented ample evidence for the court to find Mr. Fry improperly changed course, had a cracked windshield, and was driving while under suspension. The trial court was in the best position to judge that evidence, and there's no evidence to show that the trial court lost its way and created a miscarriage of justice. Therefore, the first assignment of error must be overruled. The second assignment of error was whether the trial court erred when it did not give Fry a jury trial. Under the revised code, section 294517, Ohio law provides that there is not a right to a jury trial for violations that are minor misdemeanors or for violations that do not carry jail time, and for which the possible fine is not greater than $1,000. Here, Mr. Fry was charged with 2 misdemeanors, and the driving under suspension was an unclassified misdemeanor that did not carry more than $1,000 fine. Thus, Mr. Fry did not have a right to a jury trial. Therefore, a second assignment of error must be overruled. The third assignment of error is where Mr. Fry argues that the trial court erred, sustaining the multiple objections made by the state. These objections are based on relevance. The Ohio rules of evidence are clear that irrelevant evidence is inadmissible. The decision of whether that evidence or testimony is relevant is up to the trial court. During cross-examination of Officer Stout, Mr. Fry asked Officer Stout if he took an oath. He stated that Officer Stout compelled Mr. Fry to be a witness against himself. He asked Officer Stout the definition of driving, what makes an automobile a motor vehicle, what goods Officer Stout believed Mr. Fry to be trafficking in, and what a dollar is. All of the above questions are objected to based on relevance and sustained properly, as they had nothing to do with the offenses for which Fry was charged. Surely these exclusions do not amount to an abuse of discretion. Therefore, the third assignment of error must be overruled. The fourth assignment of error, much of Mr. Fry's appeal calls from Officer Stout lacking personal knowledge. This is false, and the trial court did not err in allowing Officer Stout to testify. Officer Stout gained personal knowledge that he testified to through firsthand observation. He saw Mr. Fry make an illegal turn. He observed Mr. Fry's front windshield as cracked. And lastly, based on his investigation, he was able to gain identification from Mr. Fry. And upon looking into his driving record through these identifiers, he found Fry to be under FRA suspension by the BMV. So the fourth assignment of error must be overruled. Lastly, Mr. Fry's fifth assignment of error is that the trial court denied his right to a fair trial. This court often uses cumulative error doctrine. However, in this present case, the record does not reflect any error and therefore does not reflect cumulative error. So Fry's fifth assignment of error must be overruled. If the panel has no further questions, the state would ask this court to overrule the defendant appellee's assignments of error and affirm his conviction. Thank you.
Unless there are any further questions, thank you for your arguments this morning, Attorney Dieters.
Thank you, guys.
Mr. Fry-Bay, you have your 10 minutes and you can begin.
Okay, Your Honor. First of all, when I obtained a license, that was for driving, which is in commerce. This was driving is dirty. There are plenty of Supreme Court rulings, which is fair decisive upon the land, Article 3 court, that rules that traveling and driving are two different things. Even the Attorney General of the state and United States, in a brief, states that traveling in your own property, not for hire under any circumstances, in the pursuit of life, liberty, and happiness, can't be deprived or taken away. I've never waived any rights. As a matter of fact, I objected and stated my unalienable rights given by God Almighty, which were totally ignored, as well as a Brady request, which means they withheld evidence. A demand is a constitutional right by a jury trial. It's a constitutional protection. It cannot be abrogated. David versus Welsh. There should be no arbitrary deprivation of life, liberty, or arbitrary spoliation of property. Police power, due process. That's Barber versus Connolly. Yikio versus Hopkins, also. Your Honor, the state seems to, first of all, let's reflect that I am here in appropriate persona. I am not an American citizen. I don't need a driver's license to travel. Upon learning of the law, which all statutes, codes, and ordinances that are repugnant to the Constitution are void, ab initio. In addition to that.
So, Mr. Fryby, you're saying that you are not an American citizen?
No, I am an American national. And it's documented. Status is in effect. The court never had standing. I challenged jurisdiction. Jurisdiction was never proven. The state totally ignored the record. And in addition to this, unequal things ought not be joined. No written contract is enforceable if it is made without any element of lawful contract. Parties competent in the age of consent, contract between legal or lawful entities, free and genuine consent, not obtained by fraud, deceit, coercion, or mistake. And this was intentionally done by all the above. Full disclosure was not given. I've asked for it, providing all material information that may influence a decision. Sufficient consideration, something of value exchanged between the parties was totally ignored. Certainty of terms and conditions, fixed and unable to be changed without agreement. Meeting of the minds was never achieved when the parties recognize and understand their obligations, signatures, or autographs. And wedding as recorded evidence of reciprocal consent. He who errs is not considered as consenting. Contract law case, failure to reveal the material facts of a license or any agreement is immediate ground for estoppel. That's Lowe, Dew versus Perazzo, 48 Cal at 2D 82119, P2D 34638. Waivers of fundamental rights must be knowing, intentional, and voluntary acts done with sufficient awareness of the relevant circumstances and likely consequences. That's U.S. versus Brady, 397 U.S. 742 at 748, 1970, as well as citing U.S. versus Odell, 160 F2D 304, 6th Circuit, 1947, unconscionable contract, one which no sensible man under any delusion or duress, which I was totally under duress, or in distress would make, and such as no honest and fair man would accept. I was totally and irrevocably ignored and denied due process. Party cannot be bound by a contract that he has not made or authorized. I never authorized a contract. That's Alexander versus Baldwin, 1915, 26 Cal, 589-599-147, P607. The fraudulently presumed quasi-contract that binds a declarant with city, state agency is void for fraud, ab initio, since a de facto city or state cannot produce the material fact, consideration, inducement, or the jurisdictional clause who is subject to said statute. See master-servant employee relationship, C personal private liberty. Since the consideration is the lifeblood of any agreement or quasi-agreement contractus, the absence of such from the record is a major manifestation of want of jurisdiction, since without evidence of consideration there could be no presumption of even a quasi-contractus. Such is the importance of a consideration. That's Ready Railroad versus Johnson, 7 WNSTA 317. Case law excerpts. No law requires you to record, pledge your private automobile. Nothing is so natural as to dissolve anything in the way in which it was bound together. Therefore, the obligation of words is taken away by words. The obligation of a mere consent is dissolved by the contrary consent. These are maxims of law. And this is under color of law, color of authority, which I never gave consent, and this is a total violation, and this is null and void by law, Your Honor. In addition to this, the state just violated so many laws in a matter of statutes. And the Supreme Court, a vehicle has ruled that, and the states in the UCC, a vehicle not used for commercial activity is a consumer good and is not a type of vehicle required to be registered and use tax paid, which the tab is evidence of receipt of the tax. That's Bank of Johnson versus Jones. 4 UCC Rep Service 1021-236-A2D 484 UCC TP 9-109-14. And it is held that a tax upon common carriers by motor vehicles is based upon a reasonable classification and does not involve any unconstitutional discrepancy, although it does not apply to private vehicles.
Mr. Friday,
Or
I'm just going to advise you
by
that
the
you
owner
have,
of his business.
yeah, Mr. Friday, I would just like to advise you that you have 1 minute left.
Thank you. And
You're
that
very
is,
welcome.
in view of this rule of statutory provision, that the supervising officials may exempt such persons when the transportation is not on a commercial basis, which means they must exempt them. That's State versus Johnson, 243 P 107360 CG as section 94, page 581. See, annual report of the Attorney General of the State of New York issued on July 21st, 1909, Albany, New York, pages 322 and through 323, which reads, there is no requirement that the owner of a motor vehicle shall procure a license to run the same, nor is there any requirement that any other person shall do so unless his process to become a chauffeur or a person conducting an automobile as an employee for higher wages. Yours truly, Edward R. Malley, Attorney General. See the laws of New York, Chapter 53, 1361. And I know I don't have enough time. I'm going on and on. Freedom to travel is indeed an important aspect of a citizen's liberty, which are first concerned with the extent of any to which Congress has authorized its curtailment. Roads versus duels, 357 U.S. 116 127.
Mr. Friday,
use of the
thank you for
highway-
your arguments
Yes,
this
ma'am.
morning. Thank you.
Thank you.
Just want to confirm, are there any other questions from the panel? Okay, thank you, Mr. Friday. So we're going to now take your case under submission. We will be
Yes,
issuing
ma'am.
you a timely decision. I just want to confirm your address. What is your current address, please?
Zip code exempt, it is 513, no, I'm sorry, excuse me. That's Vine Street and care of Timothy Darnell Friday, 3961 Vine, Cincinnati, Ohio 45219 in brackets.
Okay, and is it you? Are you in Unit 2? Is that correct?
There is no unit. It's a home.
Okay, and just want to confirm because we have the zip code as 45217.
Oh, that's correct. I've lost that. I apologize.
worries.
It is 45217.
No worries whatsoever. All right, we just want to make sure we have the correct address so that you can receive the decision. And so, as I was stating, we're going to take the matter under submission. We will issue you a timely decision, and we wish you both a wonderful afternoon.
Excuse me. Can you give me an idea how long that decision will take?
We expect that you will receive it within 60 days.
Okay, thank you.
You're very welcome.
Thank you, Your Honor.
Thank you very much.
Judges.
Thank you. You all take care.
You too. Good morning.
Morning. Morning, judges.
Good morning.
Good morning.
We're now here on our last case, which is Barbara Couch et al. Versus Abubakar Atiq Durrani, MD et al. Cases number C190703, 704, 705, 706, and 707. If parties can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Robert Winter on behalf of the appellants in this consolidated appeal. We are ready to proceed.
Thank you.
Jennifer Mitchell on behalf of the appellee Christ Hospital, and we are also ready to proceed.
Okay, thank you. Attorney Winter, good morning again. Would you like to reserve time?
Oh, a couple minutes will do fine, Your Honor.
All righty. So I will put you down for 2 minutes then?
Yes, that'd be good.
All righty. Whenever you're ready.
Yeah, Your Honor, this consolidated appeal involves 3 claims appealed from the Hamilton Court of Common Pleas. One is the claim that negligent credentialing is not a medical claim under RC 2305.113 E3, and consequently is independent and not subject to the 4-year statute of repose. The second claim is that appellee's fraud claims are not fraud claims for the reason under the case of Gaines, Pierce v. Durrani, and other cases, for the reason that it's really not a medical case. These surgeries were performed solely for the financial benefit of Dr. Durrani, where appropriate, his practice group, Center for Advanced Technologies, Inc., and in this case, Christ Hospital. And consequently, there's nothing medical about this. It's all financial. That's the way it was pled. I know somewhere along the line, I think at McNeil, someone said it just has to be a medical benefit here, but that's not the way it was pled. I will say that this court has dealt with this issue, and we're really preserving this issue for further review. The third claim is that the fraud claims are, there's an inherent fraud exception to the statute of repose at 2305.113C, because Ohio courts, including this one and Hamilton County Court of Common Pleas, have the inherent judicial power to attenuate fraud wherever it is seen. The General Assembly didn't have to put in a fraudulent exception to the SOR as it had to for other matters. the General Assembly doesn't have the ability to remove the court's inherent judicial power to attenuate fraud. As with the other fraud claims, this court has addressed this in other matters, and we are preserving this issue for further review, unless, of course, the court wishes to review them, and we strongly encourage you to do so and make the appropriate finding. The thing that's different about this case is the negligent credentialing claim. The court has taken the position that negligent credentialing is a medical claim under the statute and is barred by the, or is subject to this 4-year statute of repose. On December 8th of last year, the Ohio Supreme Court addressed or decided a case called Evans versus Akron Medical Center, and it had the opportunity to address what constitutes an independent medical claim, albeit in the context of the case of negligent hiring, credentialing, or not credentialing, but hiring, retention, and supervision, where the physician at issue, Your Honors, was an employee, and
This was a sexual abuse. The underlying issue is sexual abuse by the physician, right? Not a malpractice action.
It was a battery, as we have contended here, is a battery, and also improperly informed consent. So the torts remain the same. She could, well, I don't know what the plaintiff could sue them on, perhaps negligence, perhaps battery. Sexual abuse was the physical thing that he is alleged to have improperly done, Your Honor. That's true. The theories, though, correlate here, because we have a battery, we have lack of informed consent, as well as the other causes of action that are medical claims.
But the Evans court didn't really look into the issue of the statute of repose, right? It was simply trying to determine what statute of limitations applies.
It did not impose or did not view the statute of repose. It did review the statute of limitations to be applied in this, and it said the statute of limitations is at 2305.10. It did not say that it was at 2305.113, and the reason for that is this wasn't a statute of repose or negligent. Wasn't a medical claim.
But Mr. Winters, isn't one of the differences between Evans in this case, the sexual battery was not, he wasn't providing medical services for sexual battery, and it isn't a medical claim. Isn't ours still a medical claim?
No, ma'am. No.
Why?
Because along the way, the Evans court stated that the plaintiff doesn't have to show the tort, or it has to show it, but it doesn't have to have it proven. And at paragraph 10 of Evans, it relied upon Schelling for the concept that the lack of amenability of to sue doesn't in and of itself extinguish a plaintiff's negligent credentialing claim, and they imposed that language within the negligent hiring claim. And then the court went on to say, apply negligent credentialing by saying that negligent hiring, retention, or supervision action is a direct claim against the employer based upon an employee's, that is the wrongful physician's conduct, that the law regards as wrongful or tortious. And then it relied upon the case of Albion versus Flower Hospital and the leading case here of Browning versus Burke. at paragraph 10. It said, and it relied in a negligent hiring claim that negligent credentialing claims arise out of the hospital's failure to satisfy its independent duty to grant and continue staff privileges only to competent physicians. And that knocks out the concept that negligent credentialing involves medical diagnosis, treatment, or care of a patient. And that's what we have here. And that's why it's not in negligent credentialing, cannot be a medical claim, and the Evans court certainly leads us to that conclusion.
They define negligent hiring, supervision, or retention. And it seems like the definition that they use, claims against an employer that would not have occurred but for the employer's failure to properly hire, supervise, or retain the employee, seems very similar to 2305.113's definition of a medical claim. And I'm just wondering what your response to that is, because
again, negligent hiring stated very clearly in paragraph 10 that negligent hiring is not a medical claim, because it's the hospital does not practice medicine. It's a claim against the hospital based upon the employer's conduct that would have been wrong had it been for the employer's failure to properly hire, supervise, or retain the employee. That's a, for lack of a better word, a human resources function, not a practice of medicine function. And as a matter of fact, while not discussed by Evans, not only do they have to hire the employee, but then they have to go and credential him or her as well, too. So one step short of that in the negligent hiring case, but they have to go on and credential. And Browning versus Burt is cited for the concept that, and the principle that negligent credentialing claim is an independent claim arising out of the failure to satisfy its duty to continue staff privileges only to competent physicians, not for negligent diagnosis, care, or treatment. And that's the difference here. That's why Evans takes negligent credentialing and negligent hire out of the concept of medical claim. And that's what I have here. I do want to say that
I want to make sure I understand what you're saying. So under 2305.13, 113 E3B, little II, it talks about results from hiring, training, supervision, and termination, providing medical diagnosis, care, and treatment, caregivers providing, and I don't want to go to the caregivers part of your argument yet. I just want to go to, so you're saying that the harm here did not result from the sort of things that are enumerated in that section?
The harm resulted from the hospital's negligent credentialing of Dr. Durrani. And that occurred before the event that were here, before the surgery at issue. It knew that Dr. Durrani was a bad actor. We've pled what those were, and they went ahead and credentialed them anyway. And then we ran into the surgery where Dr. Durrani did provide the medical services, but the hospital did not. And the Schelling case says that hospitals don't practice medicine, and its progeny as well. So
are you, I don't know, are you saying that this provision in the statute is improper? I don't.
Oh, of course.
Or are you distinguishing negligent credentialing as fitting into this section in defining it as a medical claim?
What I'm saying is that negligent credentialing cannot be the medical diagnosis, care, or treatment of a patient. That's not what medical credentialing is about.
Well, the statute talks about resulting from, that the claim resulting from providing medical diagnosis, care, or treatment, but from the hiring, training, supervision, or termination of caregivers providing medical diagnosis, care, and treatment.
And I just refer to the Browning, Burt, and the Evans case of paragraph 10, which says negligent credentialing arise out of the hospital's failure to satisfy its independent duty to grant and continue staff privileges only to competent physicians. That's where it comes from. It doesn't deal with a hospital's practicing of medicine, which it cannot do. Others can, but Christ Hospital cannot.
Okay.
Now, one thing I wanted to
Attorney
mention.
Winter, I'm going to, if you want to wrap up, I'm going to reserve you 3 minutes if you want to give us a wrap up. And then
Okay, well, it's Ms. Mitchell's turn, so
okay.
thank you.
All right. So unless there's any questions from the panel, Attorney Mitchell.
Thank you, Your Honor. On behalf of the Christ Hospital, we have been here on these cases before. Currently, I believe there are 5 claims consolidated before the court today regarding the claims of Barbara Couch, Todd Green, Shandon Simmons, Francine Cook, and Evelyn Young. And as Mr. Winter addressed, this court has ruled on all of these issues on numerous occasions in the past. And we would just submit on the record of the prior decisions as to all of those issues. And I'll focus on the supplemental authority that we've been discussing here today, the Evans versus Akron General Hospital case. And as I believe maybe even all 3 of you have pointed to, this case is not about a medical claim. This Evans case did not involve a medical claim. It involved a claim against a doctor that actually wasn't even asserted by the plaintiff. They didn't sue the doctor, they sued only the hospital. And that was really the crux of the argument that was addressed throughout the court's opinion. In that case, they made the allegation that the doctor had sexually assaulted the patient and that was not a medical claim, and that was not even part of it. So the medical claim statute of repose was not at issue. What the case then went on to address most specifically is whether or not the court or the plaintiff had to establish that the doctor had been found civilly liable or criminally responsible in order to support a claim for negligent credentialing. And really that was what the case turned on. And because there was no medical claim, they were looking, and there was no statute of repose issue here. This was a statute of limitations issue, which is another distinction that is very important. They applied the bodily injury, personal property, 2503.10 statute of limitations, because this wasn't a medical claim. Had it been, it would have been a whole different subsection, the one that we talked to and the one that applies in our cases, the 113 subsections. And here, subsection C. So when the court goes through its analysis in the Evans case, it's really primarily looking at another issue entirely, which is what they have to show in order, or be able to show in order to maintain a lawsuit against the hospital for negligent credentialing. And the court ended up deciding that they don't have to have a finding, they just of guilt or of civil liability. The plaintiff has to be able to show a wrongful action at some point throughout the case in order to prove the claim for negligent credentialing.
In essence, the Evans court is, one of the propositions is that the sexual assault is not part of providing medical diagnosis, care, and treatment. And if I understood Ms. Attorney Winters' the onset of his argument is that the acts by Dr. Tarani were also akin to a battery and were not within the providing of medical diagnosis, care, and treatment. How would you respond to that?
I would say that that this court's prior rulings have been consistent throughout on the issue of whether or not the allegations arise from the medical care and treatment rendered by Dr. Durrani. Here, there was medical care and treatment being rendered at the time of the procedures, the medical procedures. These were medical procedures. And so that any attempt to couch them as anything other would be improper. And I believe the court has pretty consistently held that all of the attempts by appellant's counsel to recast or reshape these claims as something other than what they is not proper and isn't supported by the law in the state of Ohio.
Did the Evans court deal with negligent credentialing?
The Evans court allowed a claim for negligent hiring to continue, really as just a general tort claim, it would appear, because there was no medical claim involved there. So they're bringing a claim for negligence against the hospital for hiring this doctor who sexually assaulted their client, but they're not, or who allegedly sexually assaulted their client, but they're not bringing a medical claim. So there was never any analysis throughout this decision as to whether it, is or isn't a medical claim or sexual abuse that occurred. And that wasn't, I think both sides conceded at that point that this is not a medical claim in that case. But that would not be the case in our cases in the progeny of this court and all the way up to the Ohio Supreme Court on these issues. It's just an entirely different case. And if you look at what the court is actually saying.
And would you say that negligent credentialing is different than negligent hiring, or is that part of hiring?
It's all part and parcel within the medical claims statute of repose section. The negligent credentialing, supervision, and hiring claim is all encompassed within that subsection. And that's been, I think, the position that we've taken throughout. I don't know that there's enough detail.
It's not enumerated. Am I correct? It's not enumerated, negligent credentialing?
I believe that it is described in what we've put before the court in our papers and have argued to this court previously is that it's actually more expansive than prior wording. The word credentialing itself does not appear in RC 2305.113C, but what it does address is something much broader than just credentialing and clearly encompasses credentialing as well. And that's what this court and the Ohio Supreme Court has affirmed on appeal, that conclusion that over time, the language has become more expansive to cover all different aspects of credentialing, hiring, supervision, and whatnot. But that wasn't even an issue in the Evans case. That's not discussed at all.
Right, because the Evans case doesn't have a negligent credentialing as part of a claim. Mm-hmm.
And then in the Evans case, Mr. Winter refers to this paragraph 10 about it's referencing these other cases that have been cited by plaintiffs throughout this lawsuit as somehow indicating that it's separate. But again, it fails to acknowledge that this was not a medical claim. So they weren't looking at the medical claims statute of limitations or repose. They were looking instead at the general tort .10 section, which doesn't have anything addressing negligent hiring, credentialing, supervision, and whatnot. But that paragraph doesn't say what Mr. Winter says it says. That paragraph, again, is talking about whether or not that doctor needed to be adjudicated civilly liable in order for the plaintiff to be able to maintain an action. And all that paragraph does, in relying on Schelling, is saying that the fact that in that case, the lack of amenability to suit did not preclude than bringing the claim against the hospital. So that's the proposition they're talking about there. And then again, when in reference to Albane and to Browning, again, it's just making a general statement that yes, a hospital can be liable for negligent credentialing, hiring, supervision. So again, it's not going to the underlying arguments that the plaintiffs are making about those cases, which this court has said are not applicable. The Browning case was decided before the current version of the medical claims statute of repose went into effect there, and was specifically supplanted, as this court noticed even most recently, I believe, in its Jonas opinion, which is very detailed on all these issues. But I would just conclude by saying that with respect to the Evans case, I don't believe it stands for the propositions the appellants are setting it forth as, that it doesn't change any of this court's analyses, and it shouldn't be utilized to upend any of the sound decisions that this court has made to this point in these matters. Thank you.
Thank you. Attorney Winters?
Yes, judges, first point is that the Carr, Jonas, and as of this Friday, Beckelheimer cases will be presenting this issue to the Supreme Court, and hopefully we can get some guidance from them. We'll see. Second point, negligent credentialing is set forth at 2305.251(3), I believe it is. And that describes negligent credentialing, particularly in its interface with peer review. And I believe at 3C, our General Assembly says that negligent credentialing claims do not prohibit other claims, such as medical claims. Third point, in the In re Stivic estate case, our Supreme Court said it under 2305.113(e)(3), the negligent credentialing claim has 2 points, two components. The first is the claim is asserted against one or more of the specifically enumerated medical providers. And second of all, the claim arises out of negligent diagnosis, care, or treatment. And the Evans court says that negligent credentialing does not arise from negligent care, diagnosis, or treatment. It arises from the hospital's credentialing of an incompetent physician and knowingly doing so. The hospital just can't insurmount the two-tailed requirement of the estate of Stivic, coupled with the 3 Supreme Court cases that have been decided since 113(e)(3) has been enacted, that says what negligent credentialing is. It's not treatment, it deals with hiring. And all those cases, one of the cases occurred, I agree, after Browning, but excuse me, Schelling, Evans, and the can't think of the darn case's name, but they were all decided after the enactment of the statute. There is no statutory reenactment of negligent credentialing within the statute. It's not mentioned. Had it would have done so, and consequently, I think Evans accurately sets forth the current state of what negligent credentialing is. It's not dealing with medical diagnosis, care, treatment, and under a state of Stivic, it can't possibly meet that standard.
Thank you for your
That's what I got.
argument,
Thank
Frank.
you, judges.
Let me just check in case there's any other questions from the panel.
I have one question, if I may. Ms. Mitchell had mentioned somewhere along the line recently that she would want to suggested having briefing on Evans alone. Is the court interested in receiving short briefs on the issue of law here?
We can discuss that, and if we decide that we do, we will notify both of you.
Okay,
Okay.
unless you put it on the table at one point, I agree with Ms. Mitchell on this particular point.
All right, okay.
Thank you, judges.
Thank you both for your arguments this morning.
Mhm.
We're going to take the matter under submission, issue a timely decision, and we wish you both a wonderful, safe, warm afternoon. And
You
dry,
too, judges.
and dry if such can be had.
Thank you for your time.